Yes.
Well, your lordships have gone through the order. My first point, no reason has been assigned by the learned single judge for passing this interim order. My second point, passing of these types of interim order amounts to granting final relief to the writ petitioner without asking for any affidavit, without deciding the point involved in the writ petition. The order is not sustainable in the eye of law. These are the 2 points. Then I am coming to your lordship the facts. Kindly mark it below that 250 persons have been allowed.
200 to 250. Yes.
200 to 250. What they have sought for in the petition. Kindly come to writ petition. Page 5. I mean, yes, it কত হবে internal running page? লেখা নেই তো এখানে। Running page is 27. Running page is 27. See, no objection to be given to the CBI to submit the charge sheet to this. The seat in demonstration is proposed to be conducted at Dorina crossing by considered temporary stage from 17th December, Market Miller, 17th 2004 to 2024, with the participation of approximately 100 persons. Now, Miller, kindly come to 15 December 2024, whereby it has been sought for page 49. Page 49. See, in Bengali there is a proverb, Udlo bai mokka jai. On 15 December 2024, to the Commissioner of Police, Kolkata so-and-so, with the members of joint platform of doctors, a joint platform of 5 organizations, are writing to inform you of our intention to hold a peaceful sit-in demonstration at Dorina crossing and to build a temporary stage without interrupting any traffic movement on and from 17 December 2024 to 26 December 2004. This demonstration is to protect against the heinous crime that occurred at R.j Medical College and to demand justice and safety in our healthcare system. This is the demand. Now, my lord, immediate submissions of the supplementary charge sheet by the CBI to ensure that justice is served with the further delay. CBI will give the charge sheet or not, that will be, demonstration will be at Dorina crossing. Go to CBI place. No objection to be given to the CBI to submit the charge sheet to the court of law against Sandeep Ghosh. These are the grievances. Now let's kindly come to rejection letter. 16 December 2024, page 50. Page 50. I have given the reason. With reference to your email on 15 December 2024, this is to inform you that you are not allowed to hold your proposed program at that place from traffic point of view, as there is every possibility of traffic congestion and inconvenience to general public at large because of the said program. It should be noted that due to ensuring Christmas Eve and New Year Eve, large number of people are coming from different parts of the state and outside for shopping, market activities, day outing at the Park Street and New Market and its surrounding areas, which is within the proximity of your proposed place of program. These areas have been witnessing a big footfall of people going out for festive preparation during the pre-festive days. It is also pertinent to mention that previously, same and identical program held at the place which had jeopardized the movement of traffic at Central Kolkata for long duration and caused huge inconvenience to a general public and led to breach of peace as well. Your scheduled program at the referred venue on the eve of festive season will cause great inconvenience to the people. It is apprehended that allowing such program at the proposed place will cause great inconvenience to general public, and past experience indicates that breach of peace cannot be ruled out. No reasons have been given. The learned single judge didn't say that the reasons are bad reasons. The order has not been set aside. Order has not been set aside. Now, my lord, kindly come to my stay application. I have given my lord, kindly just I tell you lots of the backgrounds. Kindly recall. Then, my lord, one lady doctor was, unfortunately, one lady doctor was raped and murdered. on 8th or 9th August 2023. My lord, a petition was moved before this court. The Honorable Chief Justice, Honorable Chief Justice, my lord Justice Bhattacharya, was pleased to pass an order for CBI investigation. Suo motu proceeding has been taken over by the Supreme Court. Supreme Court directed the CBI to continue the investigation. Supreme Court is monitoring the matter time to time. Time to time matter is coming before the Supreme Court. Now, my lord, in the meantime, CBI has filed a charge sheet. And charge sheet, only one name was there. That's called, what is his name? Sanjay Rai. Only one name. Now, since Sanjay Rai has been given the, my lord, earlier Dr. Ghosh and the Oshi Tala police stations were arrested. Since no charge sheet was filed against them, both the two persons have been enlarged on bail by the appropriate criminal court. Now their demand is why Sandeep Ghosh should not be arraigned as an accused. Well, can it be any demonstration? Now Supreme Court is monitoring the matter. Either let them go. If one has taken a the judicial course of proceeding and we going by that, one must believe in that. Either you go by there in the Supreme Court, or you go to the appropriate criminal court. Two remedies are there. But for a single issue, every day there you have seen the umbrellas of the associations are there. They have said it in the petition. Now umbrella will do it. Thereafter another one will do it. Thereafter another one will do it. Thereafter another one will do it. What is continuing in this? Now let's leave aside these things. What are the difficulties we are facing? And my lord, every time a festive vacation is selected. Durga Puja, I will do it. Kali Puja, I will not do it. Chhath, I will not do it because nobody will come there. Again, Christmas vacation, your lordship knows, Derana crossing and these roads are fully crowded. Notice has been given 17 from 17. Last moment will come to the High Court. High Court will pass an order. State will not be able to take any step. If you have we could have rejected long back. Matter could have fought out before the High Court. We are having our points. We have to say, in any one case, we are having points. Now, my lord, how this can be done? My lord, kindly see, I have said in paragraph 11 of the stay petition, kindly come to. And everything has to be done to the metro channel. Just in front of metro, which is called metro channel. And behind that, another channel is there, Y channel. They will not go to anywhere, metro channel. See, my lord, the Dorina crossing esplanade is one of the most important crossing in Calcutta in view of the large number of vehicles and a large number of crowds that passes through the said crossing. If any type of dharna or demonstration, even for an hour, is allowed at a said crossing, the entire traffic system of not only the esplanade area, but also the southbound area and northbound area would be disrupted. Furthermore, the Dorina crossing is in the vicinity of the esplanade metro station, as well as the central bus terminus at Shohid Minar, which leads to large number of footfall at the said crossing. That apart, during Christmas occasion, a crowd of large number of people come from different parts of the state and outside for shopping market activities, day outings at Park Street and New Markets and its surrounding areas, which are within the proximity of the proposed place of sit-in demonstration. Then Miller kindly come to 14. It is stated that it will be difficult for the police personnel to manage the crowd of if such a sit-in demonstration allows to happen. And there have been incidents of cascading traffic disruption and serious law and order in such sit-in protest when these are allowed by this honorable court in the past. I will show to your lordship, my lord. Kindly see when this court has allowed earlier, and this high court is always passing an interim order giving it. But this time we have come to your lordship. See the crowd. See the crowd earlier. See the crowd.
He's a crowd.
Christmas vacation, Rasta traffic, cascading traffic. These are the grounds. These are the grounds they are pointing out.
It shows the ground back in.
Let's see.
Which is traffic.
No, I can show to your lordship different roads traffic. See, Kesidas in front of Kesidas. See in Chandni Chowk. These are all surrounding areas. I am not referring even the RR avenues. The RR avenues, your lordship will be surprised to see the crowd. Now, my lord, therefore, my first point is that these are the facts before your lordship. My lord, every time, without giving the time to the state, is coming to the High Court, single bench is passing the order. By night, I have to implement. And we are not getting the time to prefer an appeal even. Kindly appreciate this. If you want to hold a demonstration from 17, why did you not wrote the letter 15 days back? We could have rejected, it would have been tested. We are having to tell some points before the court, and points needs to be decided now. Points needs to be decided whether they are entitled to do it or not. And in an event for which Supreme Court is sitting over the matter, if the CBI has not given the charge sheet against Dr. Sandeep Ghosh, go to the Supreme Court. Go to the CBI. Go. Who is, why they here? Go there. We have nothing to do with this. Get arrested everyone whom you desire to do it. Law and order situation will be completely violated. 11 o'clock, 12 o'clock, 1 o'clock night, singing, dancing, whatever is not there. Is a demonstration is going on in Calcutta. There are places you go, press people will go, wherever you will see it. You want your focus, it will be focused by the press. And you take your people there. No reason has been assigned. Order is bad. Number two, these types of interim order amounts to disposal of a writ petition or granting a final relief. Order is bad. Now, my lord, I will show to your lordship just few judgments. But I need to. This time I need to. Whether I win or I lose, whatever, maybe I need to do it now. Points need to be decided now. Now, my lord, kindly see fast. First, I will cite to your lordship a judgment. (2004) Volume 5 CTC 554 is a Madras High Court Division Bench judgment.
554.
No. CTC
554.
554.
The Madras High Court judge.
My lord, Madras High Court judgment. There, my lord, like good number of judgments have been given. I will show to it that from there. That is Rama Mutharamalingam, State Pursuance versus Deputy Superintendent of Police. My lord, first your lordships kindly come to paragraph 9. Under our constitution, The legislature, the executive, and the judiciary have three own broad spheres of operation. Ordinarily, it is not the proper for one of these three organs of the state to encroach upon the domain of another. Otherwise, delicate balance in the constitution will be upset and there will be a reaction. Maintenance of law and order is ordinarily an executive function and is ordinarily not proper for the judiciary to interfere in this matter. The administrative authorities have expertise in law and order problems through their long experience and training, and the court should not ordinarily interfere in such type of matters. The judiciary must therefore exercise self-restraint and not try to interfere with the functions of the executive or the legislature. By exercising self-restraint, it only enhances its prestige. This court should not ordinarily interfere in administrative matters since the administrative authorities are specialists in matters relating to the administration. The court does not have the expertise in such matters. Court is saying how much will be the length, breadth, crowd, expertise in such matters, and ordinarily should have such matters to the discretion of the administrative authorities. It is only in rare and exceptional case where the Wednesbury principle applies that the court should interfere with a Tata Cellular versus so and so. In Haryana, paragraph 12, in Haryana Financial Corporation and another versus Messrs. Jagadamba Oil Mills, the Supreme Court observed the High Court cannot sit as an appellate authority over the decision and orders of the quasi-judicial authority. It follows equally that it cannot do so in the case of administrative authorities. In the matter of administrative action, it is well known that there are more than one choice is available to the administrative authorities. They have a certain amount. They have certain amount of discretion available to them. They have a right to choose between more than one possible course of action upon which there is room for reasonable people to hold differing opinions as to which is to be preferred. Then your lordships kindly come to, that's most importantly, paragraph 13, after Tata Cellular, lordship kindly see, after Tata Cellular has been quoted 1 to 3. In the same decision, the Supreme Court observed that judicial review is concerned with reviewing not the merits of the decision, but the decision-making process. The Wednesbury principle says so and so, as Lord Denning observed, the power to overturn executive decision must be exercised very carefully, because you have got to remember that the executives and the local authorities have their very own responsibilities and they have the right to make decision. The court should be very wary about interfering, and only interference in extreme cases, that is cases where the court is sure that they have gone wrong in law or they have been utterly unreasonable. Otherwise, you would get a conflict between the courts and the government and the authorities, which would be most undesirable. Last paragraph, lordships kindly see, last and another 2 paragraphs, paragraph 19. In our opinion, adjudication must be done with a system of historically validated restraints and conscious minimization of the judge's preferences. The court must not embarrass the administrative authorities and must realize that administrative authorities have expertise in the field of administration, which the court does not. In the word of Chief Justice Nile, I have very few illusion about my own limitation as a judge. I am not an accountant, electrical engineer, financier, banker, stockbroker, or system management analyst. It is the height of folly to expert judges intelligently to review a 500-page record addressing the intricacies of the public utility operation. It is not the function of a judge to act as a super board or with a zeal of pedantic schoolmaster subsisting the judgment for that of the administrator. Kindly come to paragraph 22. Keshavananda Bharati's case has been cited. We know the Keshavananda Bharati's case as the basic structure is a famous case for that, and the 7 judges did that judgment. See, in exercising the power of judicial review, the court cannot be oblivious of the practical needs of the government. The door has to be left open for trial and error. Therefore, in every administrative decision, court will interfere. I have referred this appeal. Although 23 has been started, I have preferred this appeal. Earlier, High Court has passed the order. Accordingly, Derina crossing was allowed. Now, at least in one place, I have to say, this is the questions of law has to be decided. Nobody will decide the law. One party will get the order, will hold the demonstration, causing public difficulties. That is also not allowed. That's the reason exactly on 20th night, Milord, we have sent the appeal and stay application by the mail. Anyway, Milord, this Honorable Chief Justice thought that it would be hard on Monday. It's all right. Now, Milord, kindly see, next judgment I want to show to your Lordship. Reason. 2002 SCC 514. 2002, 2002 9 SCC page 514.
Now.
2002 9 SCC কত বললাম 514. Paragraph 3. There is nothing to indicate that any notice was issued and adequate opportunity given to the appellant to file a reply in opposition to the writ petition. The copy of the order filed also does not indicate any counsel being present. Here, counsel was present on behalf of the appellant who objected without giving any reason whatsoever. The orders were passed by the High Court directing the release of the truck and goods. This was the only prayer in the writ petition, which in effect stood allowed by the impugned order dated 17 November 2000. It is unfortunate that the High Court has given no reason whatsoever in support of its order. It is expected that when interim orders are passed, which in effect result in the writ petition itself being allowed, the High Court must give reasons in support thereof. Then, Milord, kindly come another two judgments. Milord, 2005 9 SCC page 733. 733. To say the least, approach of the learned single judge and division bench is judicially unsustainable and indefensible. The final relief sought for in the writ petition has been granted as an interim measure. There is no reason indicated by learned single judge as to why the government order that so and so was to be ignored. Whether the writ petition was entitled to any relief in the writ petition has to be adjudicated at the time of final disposal of the writ petition. This court has on number of occasions observed that the final relief sought for should not be granted at an interim stage. The position is worsened if the interim direction has been passed with a stipulation that the applicable government order has to be ignored. Time and again, this court has deprecated the practice of granting interim order, which is practically give the principal relief sought in the petition for no better reason than of a prima facie case having been made out without being concerned about the balance of convenience, the public interest, and a host of the other considerations. The other judgments have been there. This no, actually. Now, 2003 volume 6 SCC page 65.
65.
Page, my lord, 65.
Reference to bolo.
2003 volume 6 SCC page 65. Kindly come to paragraph 14. We find it difficult to accept the reasoning of the learned counsel for the respondent that the order in question is an order in equity. For an order to be an order in equity, it should be equitable to all parties concerned. We do not think the impugned order has taken into consideration the interest of the revenues, as was expected of the court entertaining an appeal against a money decree. The respondent herein, according to the appellant, collected the tax from the passengers, which was payable to the Union of India as an agent, and used the same for its own use. Its contention before the authorities that there was no default has been rejected by the so and so. It is there further case that a certain amount deposited available with the customs authority as security for the purpose of taking back of the benefit to their country should be adjusted towards the respondent dues has also been negative by all authorities. In such circumstances, entertaining a petition in his writ jurisdiction to grant a liberal installments at the respondent to pay the dues, that too only a part of the dues, in our opinion, cannot be considered as an interim order made in equity. Therefore, the order of the High Court on the facts and circumstances of the case cannot be termed as an order in equity which ought to not to be interfered by it. Learned counsel for the respondent, however, contends that there is a serious dispute as to the liability of the to pay this tax, because it is alone is not the agent of the Union or India in collecting such a tax, because many a time so and so. But this is an issue which is not yet decided by the High Court. Whether he is having any right or not, leave fundamental right or whatever the right, democratic right, this point has to be decided. Fundamental right or democratic right cannot be enjoyed by any person at the cost of derogation of any other fundamental right or democratic right. State has to see the fundamental rights of the others also. This is not the fundamental rights are limited to few persons who are coming before the court. Nothing has been decided, nothing has been adjudicated. Kindly come to paragraph 17. I'm putting paragraph 17. Seen from any angle, we thank the High Court as urged in granting the impugned relief to the respondents, which in our opinion is in the nature of a final relief, which on facts and circumstances of this case, without deciding the issues involved in the writ petition, could not have been granted. Therefore, we allow the appeal and set aside the impugned order. The NOC, which is said to have been issued previously, stands revoked. Remember, if any by the respondent would be given credit or just in the manner to consider appropriate to answer in the pending on writ petition.
No, really.
Urgency cannot be looked into only from the angle of the writ petitioners. If you wanted to do it, you could have given the 15 days back. And what is the, I do not understand why these days. Let's assume, there he is having a fundamental right. But why this Christmas vacation? Whole crowd goes to the Esplanade, New Market, etc. Park Street. It's a celebration. Celebration of the people. They don't have any right. They don't have the right to go to marketing. They have to stop in the Esplanade. A balance should be created by the court. Apart from that, whether they are having any right to sit in demonstration or Derona crossing, this is another point of law. Earlier it was done because of the High Court's interference, High Court's order. And every time the problem is with us, every time on Friday or on the previous night, order is executed, we have to execute the order. I have a right of appeal, states also have a right of appeal. Will it not be looked into? Why the High Court has entertained a petition on 18th, 7th, 19th, it was taken up at 20th. When High Court knows the state has to give an affidavit. State is seriously objecting. High Court has to decide the questions of point of law. No point of law has been decided, my lord. The trial judge on 19th said you come along with the orally, you come along with a map. One has to come up. It is not the way of proceeding that High Court should undertake. Every party should be given the equal chance. And kindly see in the order itself, we have objected. We are having a serious objection. And see the prayer of the writ petition, my lord. Page 35. এটা আমার সঙ্গে মিলছে না এটা পেজগুলো একটা লেখা। But kindly see B, issue a writ of mandamus directing the respondent to allow the petitioner to continue with the demonstration at Dorina Crossing Esplanade, Kolkata without any undue interference by the police authorities. Number 2, issue a writ of mandamus directing the respondent to permit the petitioner to set up necessary infrastructure, including a stage as design and decoration of the incremental. Issue a writ of mandamus directing the respondent to provide equal treatment, so and so. The final, more so, my lord, unfortunately, in the petition itself, it has written 100. The council is saying no, this, 1,500, whatever it may be. And court, is it not the responsibility of the court to see the aberrations of the petition itself? Therefore, my lord, I am praying for, my lord, stay of operation of the order, because a huge crowd is there. Let the point be decided. If the point ultimately decision, your lordships can take up. I don't mind, my lord, all the points can be decided. Decide the points regarding their right. Thereafter, any, my lord, it is not that 26th January or 23rd January or 15th August. It has to be done on that day. And let them go to the Supreme Court. Supreme Court is season of the matter. Sandeep Ghosh, whether Dr. Sandeep Ghosh would be made an accusation, go and say there. Go to the appropriate criminal court. Demand is to. Let me take it, Millard. I very sincere, Millard, very honestly, I am saying that I am saying this. I am really saying this, and in Parliament also I have said. Independence of the judiciary does not depend upon the fact. Depend upon one factor, that they are succumb to the government or not. Independence of the judiciary also depending upon the fact whether the judiciary succumb to the pressure given by any persons created through the press. Today, balance has to be created. And few presses are there, they will run. Because of that, High Court will pass interim order. No chance, nothing. And all sincere steps, my lord, we have taken. If after passing of the order was uploaded at 6:30. And kindly see, we have sent it in the night itself through the mail. Intervening Saturday, Sunday. And every time all petitioners would take the advantage of intervening holidays. So the order is implemented. Lord, kindly stay this operation of the order. These are my submissions, people.
Yes.
Thank you for allow for
Normally, I do not take without technical issues, but here I have to take. Who has affirmed this affidavit? The officer in charge of Hyacinth Police Station, is he authorized to represent the state in appeal?
And who is filed an appeal? Who has filed
The
an
commissioner of police is the appellant. He is the head of the police organization.
State of
West Bengal
Secretary.
Commissioner of Police.
Chief Secretary,
Huh?
Additional Chief Secretary,
Then
and the Commissioner of Police, and the officer in charge. He is the officer in charge for.
he is one of the respondent.
Hmm.
Now, therefore, he is speaking without on his own behalf, not for the state. And the points which have been raised, Lord, I would most respectfully submit, Lord, not to be decided, gone into at all. Lord, there is no law which can prevent, Lord, a person to exercise his fundamental right. And then again, my lord, the affirmation, paragraph 1 to 10 is knowledge and rest is derived from records. Which records nobody knows, and what are the affirmations made? You know, a very funny stand is taken that there will be a crowd. So what's the wrong in if there is a crowd being seated separately? And where is the specific statement that because of this demonstration, the traffic disruption is created? I want to get this statement specifically because I will show from record, from the, the CCTV camera and other things, what has been done. There is no question of any obstruction of any traffic, no question of any obstruction of movement of common man. That they have caged us. I will be shocked to see. The Honorable Court was so kind enough to direct that you have the stage of this nature and give a demonstration. They have, my lord, put on guardrail surrounding the stage only. So nobody not even a single person can stand there to hear what is their cause. Would your lordship will see from the video recording? Lordship, would you know? But is this the way state government, my lord, wants to ensure somebody's, my lord, enjoyment of fundamental right? And where is, my lord, the traffic obstruction? The revelers of 25th of December would not come the Dorina crossing. They will walk down, if at all, to the Park Street. That's the holy place, they think. Or it was made them to believe that's the holy place.
That is an order also for rain guarding, I believe.
Yes,
An order
but the order is kindly comes to the order.
that it should be guarded by a rail.
Yes, not the guarded by the rail, the
roadside.
area, so that nobody really feels
Roadside.
obstructed.
That is what I believe. Let me confirm this. Probably that's an.
Then for what?
indicated
For this?
You know, the
Side জায়গাগুলো
That is not exceeding and from the backside of the stage to
Yes.
a guard rail,
from backside of the stage.
which will encompassing the crowd of the followers.
Yes.
of the organization. The same cannot exceed beyond 20.
Yes, therefore, my lord, the guardrail should be put in a manner so that more than 100 persons cannot assemble over there. And here, can't you see the guardrail
even besides
encircling the stage?
even
And Lord, if the whole argument,
all adjacent area was
if I may say so with deepest of respect of the OC concerned, funniest of the argument, that crowd would be there. Crowd would would be at the Dorina crossing where, my lord, the doctors are demonstrating. Crowd will go to Park Street.
this is
But
the
these are all moving crowds. And this argument was advanced before the honorable single judge, having considered he has passed an order. What's the wrong in this order? Now, I would again submit, my lord, that we don't have to take any permission for holding a demonstration, which is my fundamental right under any law. But another division bench, I didn't bring that order. I recorded that this submission of sufficient reasons to be taken into consideration. Why we inform police? So that there is no law and order problem. Police might not subsequently come and say they didn't inform us that you were assembling over there. And when the refusal comes, my lord will be shocked to know, my lord, we were told carry on, no problem. And just the day before, they say, no, we can't give you permission. Now, in this background, the demonstration is going on. Where is the government that because of the demonstration, the traffic disruption has been caused?
same area the chief minister করেছে for 20 days during puja. যাচ্ছি আমি তাহলে। এই সকালে শুরু করছি।
Now, when such demonstration is being permitted, my lord, to different political groups. Now, we do not belong to a political group, we're doctors. No objection. No objection. Why this? My lord will not find any answer. It's not pleaded even. With urgency, this stay application mode, where is the pleading that because of this order and compliance of this order has caused traffic disruption? I want this single word. Or because of this, movement of human traffic is obstructed. But in absence of the principles which Mr. Bandyopadhyay sought to advance, relying on the judgments, with deepest of respect, has no manner of application in the facts and circumstances of the case. This again I say without exercise of fundamental right of peaceful demonstration. This is not any administrative order passed pursuant to an administrative authority and which is under challenge. No. Here we are challenging the authorities' exercise of power having no support of law to curtail my fundamental right. What is to be decided? I don't have any fundamental right to demonstrate. No, I don't make any further submission. Appeal to your lordship, Lord. It's going on. Let it continue. There is no question of any obstruction. Lordship may please to record this. There is no question of any obstruction by the demonstrators who are demonstrating over there, the doctors and their sympathizers. Two-wheeler revelers who will go to enjoy Christmas Day. And that's the only worry I am told. But that's also a shoddy worry, it's not the genuine worry. But I will not make any further submission on this.
So, Bhattacharya, have you challenged the order of rejection of your prayer to hold demonstration?
Without the prayer kindly says, permit me to allow the demonstration, is also, my lord, in a way challenging the order of. Kindly come to my
In the
prayer.
meantime, a decision has come.
My lord?
In the meantime, a decision has come.
Yes.
Considering your prayer at page 50 of the stay application, is it under challenge or was it under challenge?
Yes, in a way. My lord, kindly come to page 50. My lord, this, my lord, triggered the repetition, and there my prayer, my lord, the drafting and language may not be very happy, but kindly see the prayer, which is the prayer made.
Show us that it was under challenge. You have prayed.
My lord,
for
my
setting
kindly
aside.
come to my prayer. This is the challenge, but
Which prayer?
respondent allow the petitioners to continue with their demonstration. This is, in fact, a challenge to the negation of the order. If I say, Lord, I could have written that set aside that order, but ultimately that would come down to that permitting me to hold the demonstration. Now, this prayer was taken to be prayer, my lord, in effect, challenging the.
This prayer was considered. You made a prayer before the authorities.
Right, so.
Authorities considered and rejected.
Then I come
That
before
is
this
not
court.
under challenge in the writ
No, my
petition,
lord, this is.
unless you satisfy that it was your
But
prayer.
this
you
is under challenge because of these prayers. Kindly come to the prayer. I once again will read for my consideration. What would I sought for? Directing the respondents to allow the petitioners to continue with their demonstration at Dorina Crossing. They said you cannot. Therefore, I come before this court and say, allow me to do this. Because it would have been apt.
You have more experience than all of us
Therefore, my lord,
on the ground of, on the pleadings.
yes.
Tell me,
My lord, pleadings are, my lord, sufficient. My lord, construction of language is might be, my lord, not very happy, I admit. But, my lord, what is the effect? If I say that allow me to hold the demonstration, it means that that order should go. And then again, permit the petitioners to set up necessary infrastructure, including such and such. Why this permission is called for? Because they had refused it. Therefore, in a way, my prayers are there. May not be, I say, may not be happily drafted. Instead of asking for setting aside that particular order, the learned
so
draftsman has done it.
what you want to convey is that what is not patent is actually latent.
That is the point. So therefore, my lord, demonstration being, my lord, is part of my, my lord, peaceful
Who has
demonstration.
drafted?
I don't know, must be some juniors, correct? Oh, very new one. Now, well, that little digression, you always request my juniors who have come to me, don't keep anything in your mind and reflect the other things. Reflect what is in your mind. And the demonstration is going on, but there's no question of an obstruction. Therefore, the fear of OC might be valid. The commissioner of police doesn't feel it, that it creates obstruction. And then again, my lord, this is not only within the domain of OC Hia Street. It concerns, my lord, the OC Newmarket, OC Hia Street, and OC Park Street also. Now, for the OC Hia Street, again, I will say, my lord, probably he was overstepping or he was triggered by some other consideration.
He must be a party to the proceedings.
Yeah, party proceeding.
You have made them a party.
Yes, party proceeding. Because the venue itself comes within the OC Hia Street, but the apprehension which they expresses preferring appeal, that will create difficulty in having revelers to go to the Park Street to enjoy Christmas. That does not have any foundation.
What do you have to say about him that if an interim order is of such nature, which would really decide the
But it
final
dep-
ruling, then whether.
But
the
this is
interim order-
tried submission.
Huh?
This is a tried submission to make before this court. The situation, if so demands, an immediate necessity, my lord, then the interim order can be also passed in form of final relief. That's a settled proposition. I don't have to, my lord, argue on that before this court.
Yes.
But these are my submission.
At least.